Very, very good afternoon to the members. Thank you so much for joining and joining on time. We're going to have a very lively series of discussions on the proposed bills that have been circulated. I won't say very much about them, but I am somewhere with the judiciary who is equally engaged on these bills. Specifically, we've been looking at the dispute resolution bill. You will see that it attempts to create a body, a National Dispute Resolution Council. And there is a lot of focus when you look at the dispute resolution bill on mediation and conciliation. Part of it, of course, includes the court-annexed mediation process. The other part deals predominantly with the voluntary mediation that you and I will undertake outside the process. The heart of our discussion today will not be that bill, but we will be looking at the Arbitration Act, the proposed amendment to the present 1995 Act. Essentially, you will see that it introduces certain aspects that are found in other jurisdictions, including third-party funding, the question of fast-tracking arbitration procedures, and matters around generally expediting dispute resolution. Almost in tandem with that, possibly there's an intersection between this bill and the construction adjudication bill. You'll see references to the enforcement of adjudication decisions. Those of you who've walked this road will know that that has been a gaping chasm in our part of the world. And even we as the Chartered Institute, when we are training, we make heavy references to developments in the UK through the housing grants. Thankfully, amongst our panelists we have our emerita, who is in charge of that program in the faculty at the Chartered Institute, specifically relating to construction adjudication. So she'll be able to speak at length, and that's none other than Jacqueline Mahenya, Chartered Arbitrator. So without much further ado, I will welcome our moderator of the day. Our moderator today is Irene Itoto Echakara. I think we are all familiar with her from the LSK circles. She has held various positions in that area. I'm not sure whether, Itoto, you are still working closely with the Office of Parliamentary Affairs, but I do recall that you, at one stage of your career, worked quite closely with that part of government. So I'm sure when it comes to matters of legislation, bills, this is clearly familiar territory to you. So, ladies and gentlemen, I will hand over now to our moderator, Karibu Sana, to take us through the program of the day, to introduce the panelists that will be speaking specifically on the question of the arbitration amendment. Karibu Sana, Madam Moderator. Welcome.
Thank you, Professor. Thank you, Chair. Thank you, CEO, Acting CEO, for their introductions and for the words that you've given. Yes, I'm still pursuing legislation in different areas, not specifically with the Law Society. I would like to welcome everybody from wherever you're connecting from. Good morning, good afternoon, good evening, etc. Welcome to this session, to this webinar. My name is Itoto Echakara, Irene also. I'm an advocate of the High Court of Kenya, and I run a consultancy, Legal Development Services, that's SEDELE, which focuses on law policy and legislation, of which I'm passionate about. It's good that Professor has given us a brief overview of the subject. So what I would like to do is invite the panelists. We have about 5, including the professor himself, to introduce themselves, what they do, and then now we can go into then conversation. We are going to structure the conversation around 5 questions, and we will have a question, discussion, and then Q&A, and that way until the end. So let me invite the panelists right now, starting with Georgiadis. We have Georgiadis, we have Engineer Luot, we have Professor Mtuma, and we have Emeritus Waihenya. Kindly introduce yourselves. Karibuni.
Thank you, Itoto. My name is Georgiadis Haseke. I am a partner in the dispute resolution practice group at Mohammed Migai Chambers, and also a lecturer of law at the JQuat School of Law. It is a pleasure to interact with all of you. I hope we'll enjoy and perhaps have an enriching deliberation that will inform what is sought to be achieved in terms of enriching the proposed amendments to the arbitration. Thank you.
Georgiadis, could we see your face, please, so we know who we are talking to, who the voice is? Asante.
Sorry about that. I think it's disappeared. I hope everyone can now see me.
Yes. Yes, thank you.
Thank you. Yes.
Yes, we'll have engineer next. Thank
you. Sorry for that. I hope you're able to see my face.
Yes, we are.
Thank you so much. Our chair emeritus, and delegates, welcome. My name is Engineer Odhiambo Aluoch. I'm a consulting engineer, civil structural. I practice dispute resolution as a DAB, as an arbitrator, as an adjudicator. And I don't know much I was supposed to say about myself. I'm a director at CIAP, editorial committee. I sit in NCIA. I train, I mentor, and I write. I think that will be a brief history of, or a brief bio of who I am. And largely, I practice in Nairobi and within Africa. Otherwise, thank you. I look forward to a very engaging conversation. And please, let's feel free, and let's have a better legislation at the end of the day that is all inclusive. Thank you, and I'm happy to see some of my seniors here. I'm very, very much privileged. D'Souza, thank you so much for joining hands in this. Thank you.
Thank you, engineer. Can we see and hear from our emeritus, Waihenya Jacqueline, if she's on? I know she's known, but doesn't have to always introduce yourself. There might be new people.
Okay, good afternoon to you all. I'm trying to get settled. I'm not sure what I can say by way of introduction. My name is Jacqueline Waihenya. I'm a chartered arbitrator. I've had the privilege of serving the Institute in many capacities. And I'm looking forward to engaging with you on this subject because I represented CIAB in the National Steering Committee that developed the National ADR policy that has given us the current session of paper number 4, and the bills, the 3 bills that we'll be discussing in the next so long. I had the privilege of chairing the subcommittee that was in charge of legislative proposals, so I feel very happy to see that the proposals that we made are now coming to fruition. So there'll be quite a bit that we'll be able to share this afternoon. Thank you so much, Madam Moderator, our chairman and CEO, my fellow panelists, and of course, you, the most important, our attendees this afternoon. I look forward to continuing with the engagement.
Thank you, Emeritus Chair. And our last panelist is Professor Mutuma, who has also introduced himself. So I think we'll go into the first question. Sorry, let me go through the questions that we'll be looking at this time. So we'll be looking at one, an overview of the...
Sorry to interject.
Yes, yes.
Just to let you know that I am still here with the judiciary, representing the Institute in these discussions. We are here also with senior members of our Institute, Senior Counsel John Ohaga. So I will beg not to multitask too much and to attend to what the judiciary is saying, seeing that there's going to be another series and probably weigh in towards the end of the discussion. Your kind permission, moderator.
Thank you, Professor Chair. Well noted. He will contribute accordingly, as he's mentioned. I was just going to go over the questions that we'll be looking at so that we can have some conversations. We'll start first with an overview of the Arbitration Amendment Act. I'm not sure if everyone has had the opportunity to review it, but we will have that overview. And Chair Emeritus will be kind enough to maybe just give us the overview in summary so that we're able to follow along. And then the following question will be highlighting the key issues that are addressed by the amendment bill and what they sought to cure, because I'm sure there were issues that they were trying to cure. And then thirdly, we look at the effect and impact in practice of this amendments, and then we look at existing gaps, and then finally we look at the ADR policy, future outlook, and the particular would be arbitration. So we'll go through each question. So the format will be, we'll go through the issue or the question, have maybe about 20 minutes, and then open up for Q&A for about maybe 5-10 minutes, and then proceed to the next round until we come to an end. That said, let me ask the Chair Emeritus if she could give us an overview of the Arbitration Amendment Act. Thank you. Karibu, Emeritus. Sorry, I think you're muted.
Sorry. My apologies. I have quite a number of Yes. So can you hear me now?
Yes, we can. Thank you. Please proceed.
Okay. Okay, great. Yes. So when we started discussing this, the bills and the law reform, actually, we came together. We were gazetted by the then Attorney General, and we had the privilege of being chaired by our senior counsel and chartered arbitrator, who is a member of the Institute. And we had very many stakeholders who came together. We were privileged to be given the National ADR Policy Baseline Survey that had been done in 2018. And that is where we started from as our foundation. So going by what had been done, there had been quite a number of interventions that had been engaged in up until January 2020 when we took over, and we had stakeholders from the judiciary, the Attorney General's office, the National Assembly, Senate, NCIA, Intergovernmental Relations Technical Committee. We had APSEA, the Council of Governors, LSK. We had academia, the Consumer Federation of Kenya, KEPSA, and the civil society, stroke faith-based. And our role was originally to look at what was pertaining then. And from the baseline, we found that there was a tendency to confuse arbitration and mediation. If you would recall, mediation had been then within the court systems from 2016, and therefore the words ADR, arbitration and mediation, tended to be used interchangeably. And of course, that was also closely following on the heels of the new to Agrovet decision, which CIAB had also participated as amicus. So when we sat down, it became apparent that we first needed to distinguish the different mechanisms. And of course, when the mechanisms were identified were arbitration, which had been around in Kenya since the 80s. And of course, the act that came into being in 1995. It had been amended in the year 2009 to align with the amendments that came from the model law in Citro in 2006. So the Arbitration Act became a critical instrument for us to consider. And because it existed, and because there were provisions also for the mediation in the Civil Procedure Act, and providing for mediation accreditation, we thought that probably the best way was to make proposals for legislative action, which would then give us an idea of the overarching expectation of how ADR was going to go. Because if we didn't intervene, we would have left it to grow organically, and possibly would have lost the opportunity to standardize. So the first thing I'll say about the statutes, the three of them, is that they were aimed at not formalizing, but standardizing the practice of ADR, and also to take cognizance of the fact that these were highly specialized areas. And even though there were alternatives to litigation, then we were looking at instruments that would create a level playing ground, something predictable, and something that would also speak not only to the local situation, or what we call the domestic in arbitration speak, but also international arbitration, which is a key aspect of practice in Kenya. So some of the things to apply to the other ADR mechanisms. So without further ado, let me see if I can, I don't know whether we can be able to put up the arbitration bill, and I can see whether I'll be able to speak to the same as we're moving along. But if not, I'll be quite comfortable to speak to what we highlighted in the Arbitration Act. And then we took the draft, it was a whole policy. We took it to the Attorney General, and we met with a team that works on drafting. And they also did quite a bit of amendments to the bills to bring them to what was published in the section of paper number 4 of 2024. So because we're talking about, I can see it's now on our screens. Let me see if I can quickly go. We can look at the first thing we need to understand about the Arbitration Act is that the bill is that it is based on the current existing Arbitration Act. So it's the same format pretty much, but then we have included some amendments. So when we started section,
Chair, may interject? Maybe we could go to the end on the memorandum of objects, and then because it summarizes maybe the key areas of the Arbitration Act that were being amended. CEO, if you could scroll to the very end. It has, yes, I think that could assist. Yes, thank you.
Well, I would have preferred to highlight the real changes that we made, because this is really, it's like the philosophy, and I can't really read the screen that you have there, and what I have might be slightly different, and also what is out there. maybe I'll leave it to you to read. Let me see if I can get the screen up. Because it actually ends with the one that we are using, the one that is up there, the one that I believe it's Evelyn who has put up, is actually the act itself. The changes are they're critical, but they're not so many. Allow me to just quickly just highlight and say what they are, and then we can delve into the detail and the memorandum later.
Yes.
So
yes,
at section 2, we introduced the definitions necessitated by our developments, what has emerged. The first one is the inclusion of arbitral court. And this is arbitral court established under NCIA. We have created a definition for the registrar, who is the registrar appointed under the NCIA Act, so that we could bring cohesion within and standardization, like I said, and then also define the council, which is the National Dispute Resolution Council that is established under Section 81 of the Dispute Resolution Act. And the other thing, that is the definitions, because we have new stakeholders that also need to be clarified. The other issue we thought needed to be clarified was the provision and stay of proceedings. So there's you might see that there's a slight difference in the way where or how we hope that we'll be dealing with the stay of proceedings once an application is made. And here, the thinking was that because we now have an arbitral court, then there would be a stay of proceedings, and the court would refer parties to NCIA to appoint unless there's an arbitration agreement that provides otherwise. I guess the other likely culprit would be CIAB Kenya. And if there's another body, then the court would have been deemed to have referred this matter to that other body. And then Section 7, if you move quickly, is provision for interim measures by the court. And this was really to add another provision where we could provide for the power for an injunction or other interim orders under Section 2 to lapse arbitral tribunal, the one that has been appointed. And then under Section 9, we felt that there was a need to clarify our notices and communication so that there could be a lot more clarity. Because of the silence, and this is the current existing framework, provision for notices by electronic communication, that's email. We added facsimile, but I doubt everybody is using faxes now. But then we thought that we needed to clarify that email was acceptable and what then would be deemed to be effective communication. So that also brings in or clarifies that provision. The other area we see many challenges. I don't know whether it's a gray area, but we tend to see a lot of court activity is when it comes to appointment of arbitrators. So we wanted to clarify and also bring in the aspect of the arbitral court being able to appoint, and then also replace the High Court with the arbitral court as well. And then for completion, to have a proper and cohesive approach, then we also provided under Section 13 for grounds for challenge. This is actually becoming a very active area for any dispute resolution process. And I'm sure you have seen quite a bit of engagement by counsel in this area. So there were changes that were made to Section 13 and also Section 14 in relation to how challenges are done, when they can be done, and where the courts and which stakeholder would be responsible for which action. And then in the instance where there was a failure or impossibility to act, then we also made gave an opportunity for a party to apply for an arbitral court to decide on the termination of the mandate, and also to make such a decision final and not subject to appeal. Other areas included the withdrawal of the arbitrator. How was this, or how is this going to be done? When is it going to be done? And also giving jurisdiction to the arbitral court to do that. Competence, we wanted to also clarify what happens when the issue of competence is raised and when it can be raised, and also provide a timeline for the resolution of such applications. And then also to give jurisdiction to the arbitral court to be able to do. And when I say arbitral court, I'm talking about the arbitral court constituted under the NCIA. Moving on to the conduct, that's part 5 of the Act. There's also the issue of the general principles and duty of the parties. And we thought that it was important for us to set out the object of an arbitration, that's to get a fair resolution, and then also give freedom to parties to agree how their disputes would be resolved, in addition to telling the parties that they must do all things necessary for proper and expeditious conduct of the proceedings. And then moving to the powers of the arbitrator, section 20, we added another 6, subsection 6, mostly to provide for electronic communications. And then other provision that we thought, and because this had been litigated, is the question of settlement under section 31. And also, sorry, this is section 32. That is what is required to be in the arbitration award. And this is to say that subject to section 32B, after the award is made, a signed copy to be delivered to each party. And it was, we wanted to clarify to indicate that the award would be deemed to have been delivered to the parties 15 days after notification that the award is ready for collection. The other area that needed, and I mean, is also a very topic area, is costs and expenses. Provisions for that was made. The new thing that we added was part 4A, and this is a full provision for fast-track arbitration. I won't go through the details, but then in many jurisdictions, we call this expedited procedure, emergency arbitrator. That's what you find several institutions around the country calling this particular provision. And then, of course, we made some adjustment to part 6. This is where there's recourse against an arbitral award, and specifically on the question of leave. And this is really raised, or it became a topical issue after the U2 Agrobit case, and it also provides very slim opportunity for appeals, which is what the general practice in this space demands of us. So we thought that it was also important under the section 40 for the rules to provide for the decisions of the arbitral court, and this is under NCIA. In addition to this section 40 talks about the rules and the Chief Justice having the power to make rules. But then what we thought is that the decisions of the arbitral court also needed to be given, breathe life, to give them the enforceability. So I think one of the final provisions was to provide for a code of practice, and the provisions are also there. And we also thought that it was important that in addition to the codes of practice, we should also define what an arbitrator's relation. These are actually I think we call them the traffic light, the IBA guidelines on international conflict of interest in international arbitration. But we thought that for purposes of especially domestic arbitration, we would adopt the best practice, and there's a summary of the same. And then the rules, the rulemaking power, really that is all that we set out. And Rule 2, we said that all applications would be made by a notice of motion supported by affidavit. That is really, in a nutshell, what we provided and set out in the arbitration amendment bill. What I also think is important to highlight and will affect not only the arbitration bill, but the dispute resolution bill and the construction adjudication bill, I beg your pardon, other than the creation of codes of conduct and the relationship and how we engage with each other, is a creation of something we call the practice area committees. This would be established under the National Dispute Resolution Council. And once established, it will have some kind of, I guess, latitude. I don't want to say freedom, but latitude to be able to make directions on how the different mechanisms will be put in place, how the members will be licensed, and also how they will be disciplined. I think I can rest there. That's really a very, very high level summary of what is in the arbitration bill as it relates to the whole ecosystem under the national ADR policy. Over to you, Madam.
Thank you, Emeritus. That was a summary. And you also captured the issue of the key issues that were being addressed and what they cure. I guess we'll now need to go into the discussion of what is the effect and impact in practice for these amendments. And maybe we'll start with you, Georgiatis, then we'll go to you, Alwatch, and then Emeritus, if you can say what your thoughts are on that. Meanwhile, let me encourage the delegates, participants to use the chat or the Q&A to put down your questions. We'll open it up for questions in after this conversation. Georgiadis, please, are you able to give us your thoughts on the effect and impact of the amendments on practice, both negative and positive? Karibu.
Thank you very much, Itoto. Now, I think I will highlight certain areas, of course, with the good work that has been laid by the Chairman Emeritus. I will start off perhaps from where she did. And one of the things that I do note is that there's been an attempt to expand the definition of what an arbitral award is. In doing so, as has been indicated, there's been an introduction of an award that has been made by an emergency arbitrator. Whereas that is good in itself. However, when you look at the bill in its entirety, there is really no explanation or a definition of what this emergency arbitration is. Perhaps the assumption by the drafters were that it is something that is known, but I think for clarity's sake, we need to understand what this emergency arbitration is. My viewpoint is even fortified by the fact that, as the Chair Emeritus was indicating, we have a dedicated part that is dealing with fast track arbitration, which, if you look at the way it has been characterized, in my understanding, is not similar to what an emergency arbitration is. Similarly, arbitral tribunal has been defined to include emergency arbitration or tribunal. In my humble view, there is need from an inception perspective to not only brush around some of these terms, which might be technical in nature, and perhaps if we are going to ensure that there is efficient and effective arbitration, we try to reduce the likelihood of disputes around understanding key concepts. Having said that, I also note that the bill has elevated the principle of efficiency and cost effectiveness in the Arbitration Act. It has in fact indicated that one of the principal objectives of the Arbitration Act going forward, although of course it is something that we had always as arbitrators taken into consideration, is to promote the fair resolution of disputes through arbitration without unnecessary or undue delay or expenses. So I think this is a good emphasis, especially to the arbitrators, to ensure that this principle is upheld. Similarly, when you look at the proposed section 19A, there is again emphasis on not only the tribunal, but on this particular respect on the parties, including their representatives, to ensure that the disputes taken to arbitration are equally resolved without unnecessary delay or expense. So hopefully, the issue that we have been grappling with, which perhaps is an issue of perception within the practice circles, of arbitration appearing to be expensive, one, because of the time that is taken, but secondly, because of perhaps the charges or the fees that are levied can be addressed through these two proposed provisions. The other issue that I would want to not to mention, whereas I recognize the importance of their introduction, but I also have some qualms in terms of their practical effect. One, which was mentioned, is we now have a situation where if the High Court or the court to which an application has been made by a party seeking interim measures of relief, in particular under Section 7, and that interim measure of relief is an injunction, then that injunction cannot last more than 2 months, or as may be extended by the court. The practice has been that the moment party seeks interim measures of relief, then that gives them, or those reliefs are supposed to subsist until the arbitration process is concluded. That then removes the necessity of parties appearing frequently in court seeking extensions, or a likelihood of interim measures of relief lapsing within the period that has been given, which perhaps might affect the efficacy of the ultimate arbitral award that will come out from the arbitration proceedings. Whereas perhaps I recognize the policy perspective in forming that proposal, because we have had a situation where sometimes certain parties get interim, once they get interim measures of release from court, then they proceed like lackadaisically between in the arbitral proceedings. They maybe lose the interest or the passion that they initially had because of the interim measures that they have received from court. So I think there's need for a balance around that provision. We are alive to the fact that unless perhaps it's a very simple arbitration matter, I am not quite sure that within 2 months, parties would have concluded an arbitration, because now we are going to see a situation where parties who are in arbitration are frequently again going before the High Court or the normal court procedures to seek extensions or to argue. And as you know, sometimes when these interim measures have been granted, when a party seeks to renew, there is always probability that a party against whom that order was issued would oppose their extension, which of course might expose the ongoing arbitral proceedings in terms of their efficacy. So there is a need to perhaps rethink or relook at how we can deal with that. The other issue that I think is innovative. It is good, but we also need to be clear as to how this is going to play out. It has been noted that in the proposed bill now, where an arbitrator or arbitral tribunal makes a determination as to whether they have been properly appointed or not. I think the concept of competence under Section 17, whether they have jurisdiction, that issue now will have to go, if a party is agreed with the decision of the arbitral tribunal, will have to go before the arbitral court. This arbitral court, as has been pointed out, is established under the provisions of Section 21 of the NCIA Act. This is an organ under the Nairobi Center for International Arbitration. And the decision, if you look at the proposed amendment, the bill, the decision of that court is then final. My thinking initially was, whereas this is a good proposal in the sense that perhaps the intention here was that we should, as much as possible, remove the intervention or the participation of the normal court system from the arbitral proceedings. It left me wondering whether, through this proposed amendment, we are creating a parallel system of court outside the system, the court system that is envisaged under the Constitution. My worry is born out of the fact that when you look at how this court is established, it is actually appointed by the board of NCIA. It has a president, it has a deputy president, and 15 or so other members, including the registrar. There is no requirement there that any of these parties have qualifications that would be required of a judicial officer, in particular a judge of the High Court. And yet, when you look at the proposed Section 40A, which the chairman emeritus has alluded to, this court's decision is going to be regarded as, or is going to be deemed as a decision of the High Court. And it will be enforced as such. So if it's going to be deemed or given equivalence to the High Court, does it meet the constitutional threshold of what the High Court is envisaged? Are we creating a parallel court system in arbitration outside what is envisaged under the Constitution? And you will note that this court has given a wider mandate, in fact, where, for instance, there's been default appointment of an arbitrator, and one of the parties, of course, the aggrieved party who did not participate in that appointment, would want to challenge the appointment of a sole or a single arbitrator. That party can go to, again, the NCIA, but this time round to the registrar, who can either set aside the appointment of the sole arbitrator, or they can confirm. But yet again, if a party is dissatisfied with the decision of they can make an application before the arbitral court, and the decision of the arbitral court will be final. I'm not pretty sure if, and perhaps Emeritus Chair will speak to this, if this is a court of record. When it comes to competence, when it comes to the issue of appointment of arbitrator, and also another area when it comes to termination of the mandate of the arbitrator, we are seeing that this court again has a role to play. It is not a court of record, to the best of my understanding. And to that extent, the arbitration community, are we going then to be worse off in terms of the jurisprudence around these three areas, and in particular around the issue of the jurisdiction of an arbitrator to determine their own jurisdiction. So I think we need clarity around that. When it comes to fast track arbitration, I think this is a very good thing, as has been mentioned. It is innovative, and I think if parties are desirous of expeditiously conducting their arbitral proceedings, then they can adopt this procedure. However, I note that, and perhaps we need to be informed of the policy consideration behind this, that it is only applicable to domestic arbitration. Of course, there is a rider to that unless parties agree otherwise. So I'm wondering, what about international arbitration? Because that has also been covered, and I'm going to talk about it in a few when we are dealing with the third-party funding. There is the issue of recognition and encouragement of the parties to use technology. I think this is a desired recognition or amendment, because so far, perhaps even without the enabling legislative framework, parties have already employed the use of technology, and especially after the COVID-19, then it is only fair that the legislation gives room for the application and use of technology. Maybe I'll come back later, but finally, on the issue of third-party funding, I think we have talked about this in various forums, and it is also a welcome reform in terms of making Nairobi as an attractive seat of arbitration. And I note that the bill under Clause 18 seeks to introduce a new section, Section 39A. But in my considered view, and perhaps again, I will defer to the policy philosophy to explain to us why we thought that third-party funding in arbitration in Kenya should only be limited to international arbitration and not applicable to domestic arbitration, especially in view of the conditions that have been stipulated under the proposed section, which of course takes confidence of the fact that in certain circumstances, then such third-party funding agreements may be considered unlawful. And if that is the case, then why don't we just also allow it to be applicable to domestic arbitration? Whereas that proposal is welcome and innovative, as I have indicated, I have some qualms as well, one of which I have already mentioned, that it is only limited to international arbitration. But secondly, you'll find that the bill indicates that a third-party funding agreement can be considered to be unlawful if it violates or if it is against public policy and the laws of Kenya. So the first question I have is, what should be considered to be public policy? We have had very serious debates around what constitutes public policy. And of course, we have always reverted to judicial intervention, in this case, the High Court. Of course, we all know the Christ of all nations decision that was handed many years back by Justice Ringera, as he then was. And it has always been an issue when it comes to even where an arbitral award is being challenged on the grounds of public policy, because what constitutes public policy and who is supposed to determine what constitutes public policy? And in this particular case, it even worries me, because whereas we have said that it can be considered unlawful because it is against public policy, we have not then, or the bill has not then gone ahead to say who will make this determination. If one of the parties is aggrieved by the fact that another party is being funded and that agreement is against public policy, which forum will that issue be determined? Is it before the arbitrator? If it is the arbitrator, are we assuming that the arbitrator will be, or all the arbitrators will be Kenyan, for instance, they know public policy? If it will be the arbitral court, is it suited to determine that? Are we going to go to the High Court? And if so, what would be the procedure? So I think we need clarity, having given those conditions or indicated that a third-party funding agreement can be declared illegal or outlawed on that basis. Then we need to know how that process can be undertaken. Finally, on my part, before maybe I say something else later, is what we have been told by Madam President Emeritus on the issue of appealing against the decision of the High Court in an application for setting aside an arbitral award. I have seen there's an attempt to clarify that particular provision, section 39, by giving the conditions under which the Court of Appeal can assume jurisdiction. Of course, there's now clarity that leave will be sought from the Court of Appeal. Then the Court of Appeal will take into consideration certain three aspects that that it will consider in determining whether or not to grant that leave. The first one being that the High Court relied or to set aside on a ground which is not contemplated under the provisions of Section 35 of the Act. The second one is that the proposed appeal raises a point of law, and that point of law must be of general public importance. But finally, is a very curious ground that has now been introduced. I'm saying curious because I think it might lead to more debates, more disputes than perhaps we intended. It is of a general nature, which says that the Court of Appeal may admit an appeal on special reasons. So what are these special reasons? Would it then be based on case by case? Can we perhaps delimit what these special reasons are? In the case of Newto, which perhaps informed this area of reform, the Court of Appeal did give, the Supreme Court actually did give some sort of a guide. And it suggested that, which is now captured, that perhaps the High Court relied on a ground which is not envisaged under the Arbitration Act to set aside an arbitral award. I think this third ground that is given to the Court of Appeal to consider when an application for leave is before it might be problematic. And because we are undertaking this process, perhaps there might be need for us to rethink that particular ground. If we can clarify, that would be good. But also, just on that issue, the proposed bill now indicates.
Sorry, Georgiadis, hold on. CEO, are you able to mute? I think I hear somebody in the background. Thank you. Proceed, sorry. Is this your last point? Sorry.
Yes. That is my last point.
Okay,
so under that provision, which allows the Court of Appeal to grant leave, when the Court of Appeal has assumed the jurisdiction to determine a question of law or to determine that appeal, then its decision is in no uncertain terms final. Does that mean that we will never have a Newto moment? Supposing a Newto kind of moment arises, does it mean that a matter cannot be certified to the Supreme Court for determination? Especially, I'm asking this because we are now adopting new innovative areas, things such as third-party funding, which perhaps you have never had an experience with. Supposing an issue arises around that, does that mean that now the Court of Appeal will be final in that regard? Thank you very much for the opportunity.
Thank you, Georgiadis. He's tackled the effect and impact, and I've also seen he's tackled gaps, existing gaps within the proposal, the legislative proposal. Engineer, do you have additional thoughts on both the effect and impact and then existing gaps? Kindly proceed.
Sorry, Madam Moderator, just before my colleague, the Director Engineer Alwach steps in. Sorry, I had a 2-3 minute break.
Yes, yes.
Before I rush back into the session, I was going to request Engineer just to allow me to make 3 quick points. The first is a build-up to what Georgiadis has spoken about. This host of the High Court jurisdiction to the arbitral court. So that happens in several parts, several sections. I think that needs careful consideration given the supervisor, and you will note that it goes, the High Court has review powers that moves into constitutional references. This is very, very key. And we are asking whether, given the shrinking space between public law and private law, whether this arbitral court will have jurisdiction on matters that are specifically of a constitutional nature. So you can see that in labor arbitrations, where a lot of them touch on labor rights. You can see that in the maritime context, and you can also see that in environmental related matters. So that's a major question for debate. The other, of course, is the geographical capacity that this arbitral court has. So the idea behind transferring jurisdiction from the High Court to the arbitral court is about expedition. But if you really think about the geographical stretch of the arbitral court and the real danger of backlogs emanating, I think maybe a bit more thought needs to be given to that. And then last but not least, and this comment sort of runs across all the references to the NCIA. One such reference, of course, is Section 4 of the Arbitration Amendment Bill that instructs the court to refer parties to the NCIA for the purposes of appointing an arbitrator. So, of course, there are problems, and probably exacerbated by the fact that the NCIA is a statutory body. So it is a state corporation in real terms. And what you are doing is subsuming the autonomy of the parties and subjecting it to the NCIA rules without the consent of those parties, and notwithstanding that many of these disputes, albeit their domestic character, may involve international entities contending over specific issues with state corporations. Now, we as dispute resolvers know that when you're thinking investment and making your location an attractive seat, the investor will be asking questions about how aligned or connected a body of this kind would be with the government of the day, seeing that government entities would also be part of those disputes. So I wanted to make those 3 comments, Madam Moderator, just riding on what Georgiadis had well articulated earlier on. At this point, I'll beg to shut down again and hand over the baton back to Engineer Lodge.
Thank you, Professor. Engineer Karibu.
Thank you so much, Toto. I can see the hand of the chair emeritus up, but I'll wish to her to hold her horses a bit, because probably some of the things that I'm likely to say will require her attention. So
Yes,
she can speak after probably raise some issues.
Yes, engineer. Yes, that would be guided. She can respond, because I think there's also a number of things that mentioned. She can respond, and then we'll also open it up to Q&A as well.
She can respond after.
That's okay. That's okay. I've held my horses, engineer. Go ahead.
Thank you, Chair. I've seen you put your hand down. Thank you. I think people in this webinar can attest. When lawyers speak, you can see how the issues of law and the issues that touches on legislation are so weighty unto them. To me, coming in, I would have probably talked much on the issue touching on the technical matters and such. But thank you so much, Georgiadis. You've done a lot of exposition to this document. And I think most of the issues that you raised probably were things in my list. I'll not repeat myself on what you put across, but I'll just provoke delegates in this meeting to start thinking critically and probably make more comments on to the NCIA for consideration as this bill or as these acts are being put in place. It is always said that law must make sense in two directions. And a friend of mine one day made a joke and said that long time ago in the UK, law used to be debated, a bill used to be debated twice in order for it to make sense. The legislator must debate about it when they are drunk and when they are sober, so that the law must make sense on two directions. To us, I'll invite us that this law must make sense in two directions. Whether you are the respondent or you are the claimant, you are the referring party or you are the responding party. So it is important for all of us seated here today to interrogate this document and make a fair comments, as probably put by my colleague Georgiadis. I've looked at this document briefly, but there is something that still is not very clear that I think probably emeritus will come forth and clarify. The HIP at which the National Dispute Resolution Council is joined with the NCIA. Because you look at the spirit of this document and the three proposed bills, you realize that there is some element of a link. Section 4, paragraph 4.3.1D talk of the point of linkage between the NDRC and NCIA. But it doesn't talk about the infrastructure. But again, you read the Dispute Act, the Dispute Resolution Act. It says that the CEO at, the registrar of NCIA will also be the registrar of National Dispute Resolution Council. I don't know what this policy is seeking to cure under that context. And probably when the emeritus comes forth or us, we'll have to debate on that and just find out who is who, because you find even the arbitral court that has been mentioned, it's a creation of NCIA Act. It is not a creation of this document. And the Dispute Council is a creation of this document and is entrenched in the Dispute Act with its own composition, which probably I'll mention briefly later. In this policy, as probably my colleague Georgiadis said, that the Arbitration Act as proposed, it is trying to create two parallel, something like courts. We have arbitral court and we have the High Court. As much as better part of this policy trying to bring in the issue of the arbitral court and all that, there is still bigger reliance on high court. So even in real practice, when do I go to arbitral court and when do I go to high court? Should the decision of the arbitral court, can the decision of the arbitral court be overturned by the high court, or we have two parallel courts that are operating in this act? My proposal would be, because generally by the time parties are going to the arbitration or seeking for ADR, they are not really in the business of going to national court. And at all cost, they'll try to avoid the national court. So if at all this amendment is trying to bring in the arbitral court, then in my opinion, it should be absolute that any matters pertaining to ADR and pertaining to arbitration should then be referred to arbitral court with the leave as stated for appeal. As stipulated in the act considerably. Then on the issue still of the arbitral court, as said earlier, it is the creation of a Nairobi Center for International Arbitration Act. But then it gives the qualification. I think that is that one you missed out. Section 21(2)(c), not more than 15 years members, all of them whom shall be leading international arbitration. So, dispute counsel, again, there is a certain twist in that counsel, because that counsel, in the initial act, I think there were 17. In the proposed act, I can see there are around 14. But still out of 14, 8 of them are lawyers, 7 of them are lawyers. Being lawyers, no problem. The president of the National Dispute Resolution Council is a judge of High Court. Something that I tend to think ADR practitioners need to look at. Why should we have the council being led by, or must be led by, a judge of High Court? I don't know. In my opinion, or in my understanding, we should retain it as an arbitrator with probably 15 years of experience will be a good, proposal to look into. I'll not discuss much about the National Dispute Council, but still in the policy. Policy, you read through it, there is so little mention about the practice in the construction industry. And this is my biggest worry, because we all understand and know how much is at stake when it comes even to the national development or general infrastructure development in this country in the construction industry. But this document mentioned very little about the construction industry. And to the worst, the built environment experts is not mentioned anywhere, apart from one body be represented in the council as the Architectural Association of Kenya. That one puts me to a situation whereby I fail to understand then what is the construction adjudication bill seeking to cure. I invite the delegates here today just to look at that. If at all we are talking of this sessional paper bringing 3 bills, one of the bills, National Construction Act, and the act has, the policy has very little mentioning of the engineering fraternity, of the QSing fraternity, land surveyors. The only association mentioned is Architectural Association of Kenya. I don't know. Then, in the policy, the policy has proposed that the NDRC will have the mandate to amend the NCIA Act. Between NCIA and this policy, which document is superior? Or the proposed act, which document is superior? These are things that probably we'll look into. Let me say one or two things about the act, the proposed amendment in the arbitration bill. And moderator, you just give me a few minutes. I'm not a legal expert, but there are some few things I understand about this act. I've practiced using it for a couple of years. It is a good move. First of all, I must say, the proposal to amend this Arbitration Act is okay. It seeks to cure quite a number of things that we've had in practice. Apart from few editorial errors that are found here and there, in terms of the sections that have been quoted and all that, I think those ones also need to be addressed, like the council. It's not section 81, it is section 18. I've mentioned earlier the issue of the High Court being mentioned and then arbitral court. The distinction is not very clear. But sorry.
Sorry, see,
Okay,
could you mute?
Okay. The distinction is very clear. There is some part that the arbitral court is given jurisdiction, but then there is some results for the High Court. Of course, the High Court under the Constitution and the jurisdiction they have under the Constitution, it is okay. But them being again probably retained in the operation of the Arbitration Act, is it really curing the practice? Is it really a good thing in the right direction? And if at all it is so, then will that one make arbitration practice or ADR practice better? Or what should be done? And I see that one with all of these acts, the Amendment Act, the Arbitration Amendment Act, the Construction Adjudication Act, which probably we'll discuss on Monday. I have a lot of issues to raise on that, and equally to this act. Of course, I'll slightly probably differ with my friend Georgiadis on the provisions of setting aside of the award and all that. My only difference will be, do we need to go to the High Court? Parties coming to arbitration, first of all, have refused that we don't want anything to do with the national court. We want our issues to be sorted out of the national courts. And then now we are getting back again to the arbitral court. In my opinion, that one should not go that way. Otherwise, the act is the amendments relatively good invention, third-party funding, and such. I'm more comfortable. The fast tracking of the procedures and all that. With that, I think I'll rest there. I said with me, I'm not a legal practitioner. I don't have very many words. I communicate so much in drawings. Thank you so much.
Thank you, Alu. Thank you, Aluot, engineer. Thanks for your thoughts. Emeritus, are you able to give us maybe 5 to maximum 10 minutes of responses? I know there are many issues raised, so that we can have members ask questions, considering that we are at 3:20 and we should be finishing at 4.
Okay, thank you. And first of all, sincere appreciation for the comments that have come from both Georgiadis and Engineer Aluoj. You'd be surprised that this has, many of the things that they have said are actually the reactions that we have had, or that I have been able to receive as feedback to the bills and what the policy has or seeks to establish. and of course what the bills hope to achieve. So I know there are a number of questions, a number of comments. I also note that our chair also had something to say about the arbitral court. And I think since everybody spoke about the arbitral court, I think that is probably one of the first places that we need to focus on quite a bit. First, we still remain in situ model law country. And when it comes to the courts, there was also mention of the appellate structure. The principle, I think this is set out at Article 5 of the model law, is that the principle is that courts shall not intervene in matters governed by law unless the law itself provides for such intervention. And when we opted to go an arbitral court within the sense of the court judicial authority that is set out in the Constitution, so we need to distinguish the two. And sometimes it's difficult. Article 159 talks about judicial authority, and then the rest of the part continues to establish the courts, High Court, Court of Appeal, and the Supreme Court. The arbitral court is not part of that hierarchy or that structure. Let us agree. I hope that I can convince you that this is what we intended to achieve. And even if we haven't achieved it with the instruments that we have, that is the goal that we are looking to. This is the target that we're looking to strike. So the choice of the arbitral court in the NCIA Act was to take advantage of an arbitral court that has already been established by statute, even though it hasn't been operationalized. And you may or may not have seen that NCIA is in the process of trying to get the court members there. They've done the applications. The board, I'm sure, in due time is in the process of appointing these individuals. The intention of the NCIA Act, to my understanding, was that the arbitral court was intended to be an international arbitration court within the understanding that we have of what we see in the ICC. ICC is probably the International Chamber of Commerce Court. It's probably the ideal frame that we can expect, so that we have individuals who are specialized, who have been trained in arbitration, in international arbitration, who know the dynamics, the philosophy, and even the theory behind having an arbitral court, so that we can have quick intervention to facilitate the movement of an arbitral proceeding right from the beginning. So the court is established with individuals who are experts in arbitration. Now, I was asked whether we have a definition of who an arbitrator is. We didn't define the neutrals defined them in the dispute resolution bill. So, who is an arbitral tribunal is defined in the dispute resolution bill, and mediator, conciliator, I believe in the construction adjudicator. They are all in that bill. Ideally, for the arbitral court, an arbitration, an international arbitrator, so that we can get people who are conversant with what competence means. For instance, this new animal we are calling third-party funding, and there are new things that have come up even subsequent to the draft that we did. And then please remember that the bills that you see here, although the naming is 2024 or the date and 2025, please note that we did this policy, the draft was submitted in 2021. There have been new intervening changes, which we need to put in our memorandums as the response of the public participation process. So, and the other thing I need to say, since this was published, and since I'm sure with the judiciary, you will probably note that they are very interested in maintaining ADR centers and having ADR courts as well. So whether that will be established within the bills or the legislative framework that is proposed, or that will be done within the internal, still remains to be seen. And I'm sure they're discussing this because I have had a few snippets here and there. So how the arbitral court will look and what its role will be and how many members will be included in the definition of arbitral court will ultimately depend on how we decide or determine to amend the statutory framework. It is up to us to say we need more. I think there was some comment or thinking that we need more. The question of the expertise or the professional background, if it is something that needs to be included, is something that we can put in the memorandum as the response to public participation as CIR. This is something we are an institution that is multidisciplinary by designation and definition. So that is a point that, for the benefit of Engineer Watch and my colleagues who are from the built environment, it has been the practice to have the president of the court as somebody who's qualified to be, in some cases, Supreme Court judge, High Court of Appeal judge, and the basic one is the High Court judge. So we can expect that to be an issue that may not be really up to debate. But for the other members of the court, I don't see why we cannot have people with the competencies required as international arbitrators to be able to address the issues that are going to be referred to the court. We're not looking to replace the High Court by putting the arbitral court there. Arbitral court deals with matters of procedure. And this is where you see they'll look at the question of appointment, question of jurisdiction, even the question of interim measures. I think I saw this from Georgiades' presentation. The interim measures by the arbitral court was to give a maximum of 60 days. Anything else, any extensions would have to be done by the arbitral tribunal, the arbitrator or the panel arbitrators who are handling that matter. So there will be no need for parties to go to the High Court to extend their orders for interim protection. And therefore, that should also be a good move that will create a lot more control within the framework of the four corners of the arbitration proceedings. As we discussed this, as we said these things, because we had lawyers amongst us, we had people from different walks of life, different professions, there still is a lingering concern about, I'll call this the way they said it, the word they used was the rogue arbitrators, and therefore, this amendment to section 39 for special reason.
Ms. Kibicho, please turn off your camera. Sorry.
Yeah, I'll be very one or two minutes top, sir. On the question of the qualifications of an arbitrator, we thought that we didn't want to legislate it and to allow the practice area committees to address that particular aspect. The one area I'm thinking I need to say a few more things on is that raised by Engineer Alwoch. When we discussed the policy, please note there was a passing reference to the construction industry. And when we started talking about the different areas, the different sectors, we call them different sectors at 1.2.2 of the policy used in a specialized way, including electoral, commercial, family, environmental. We have acknowledged that there is niche practice, and the thing and the issue to send out, because we are multidisciplinary institution, is to encourage the different niche areas to develop practice of ADR in their niche areas, because they understand the dynamics in their niche areas. They're the ones who can develop the framework, and with the parts, they'll be able to do that comfortably, practice in that area. So we made several references, including not only to adjudication, but arbitration. I actually fought for AAK. That was the one everybody knew. I wish we had an engineer in the room at that particular point in time. Maybe they would have told us otherwise. But at least we have representation from the built environment. And if you go to the policy itself, you will see that the agreement by the committee, the National Steering Committee, was that we enact a distinct legislation to guide and direct the growth of and provide for mechanisms to strengthen the practice of construction adjudication. If we go by the example of international dispute resolution within the construction sector and construction law development, construction adjudication then provides a precursor to construction adjudication, and all of them feed into the process of dispute avoidance and an adjudication, and ultimately to arbitration, with the hope that arbitration becomes the last step if we use the model that is adopted by FIDIC and the ICC, International Chamber of Commerce dispute resolution approach. I hope I have addressed as many of the comments as were addressed to me. Third-party funding, I can speak to that. This is a new area, but the key problem that we had with including it in our framework was our knowledge, our thinking, our philosophy that really abhors anything that allows charm party agreements. And this could affect the legal practice. So we didn't want to run afoul of that. But then, of course, when it comes to the domestic framework, I think we need to also involve our peer institution, that is the Law Society of Kenya. I hope I've addressed the questions, and I can rest there. Thank you.
Thank you, Emeritus. I think now we can do questions. What I would ask members or participants who'd like to ask a question is raise their hands and then now unmute and ask questions. We'll take maybe about 5 questions to any of the panelists. Meanwhile, I've seen questions in the chat. Any of the panelists could answer. Let me read it out while we still wait for members to raise their hands and ask questions. There's a question on Emeritus and the rest. There's a question by Nyaga Kizinji on the issue of the arbitral court. His concern would be, is it possible to create a division within the High Court for specialization? I hope I've summarized that question. Secondly, he gives a comparative with Technology and Construction Court of the UK. Maybe the arbitral court can follow that. And then finally, the issue on Section 35 is talking about procedural grounds and whether it can affect the Article 159 of 2010. The other issue that Mr. Kithinji is asking is about the arbitral court. And he compares it with the LCIA. So maybe any of you could respond to that. Meanwhile, are there any questions from the participants? Please raise your hands. Meanwhile, any panelists can take up questions by Kithinji. Karibu.
Thank you, Toto. The question that has been raised by my friends, Dr. Kithinji, I think it is something worth considering. When we talk of technological and construction court in the UK, and he has given an example, if at all we can consider that and have like an ADR court or instead of arbitral court. I'm probably persuaded to think along that direction because the TCC in the UK has also generated a lot of jurisprudence in the field of ADR. And if we can replace that with the arbitral court, I think we'll even clear the issue of whether to have the arbitral court or high court, running parallel. And if it can be also a department in the high court, I think that one will cure a substantial amount of issues that we might have had probably with these amendments. And on the issue of Section 35 and all that, probably that one I'll leave Waihena to answer. Yeah, emeritus. But to me, on the issue of TCC, I'll support that and I'll think along that way. Thank you.
Thank you, Engineer. Georgiadis, would you have some additional thoughts on the questions?
Thank you. I think from the comments that I've seen thus far, especially from Mr. Gilinja, he seems to agree with me on the issue that I have raised, the fact that from what I understand, and I think perhaps I would require clarity from Chair Emeritus when she says that the court that is envisaged, the arbitral court, from what I've gathered from her, it appears as if it is not the court that currently exists under Section 21 of the NCIA Act. Because if it does, then I still maintain the qualms that I had raised earlier on in terms of some of the things that it will be dealing with. And I just want to perhaps highlight even further, when you look at the grounds upon which an award can be set aside under Section 35 of the Arbitration Act as it currently exists, one of those grounds is that a party can raise the fact that the composition of the arbitral tribunal is not, or was not such as was envisaged by the agreement of the parties. Earlier on in my sentiments, I had indicated that the body with the final issue, with the final jurisdiction on the issue of composition of the arbitral tribunal appears to be the arbitral court. So does that mean that we'll also have to change or amend Section 35 so that we remove that? Because otherwise it will mean that the provision which indicates that the arbitral court's decision on that appointment is final and not subject to appeal will have to be looked at when somebody challenges the arbitral award emanating from such an arbitral tribunal. So I think we need to have an internal harmonization of the proposed amendments and what currently exists under the Arbitration Act. In terms of the question that has been raised by, I believe it is Engineer Paul Kioko, whether explaining the policy rationale, I think Madam the Chair Emeritus did explain that, but I still have some concerns still, and I think those concerns reflect what the current chair indicated initially. If you look at the proposed amendment under the amendment bill, is that the default position for appointment of an arbitrator where a matter has been staged by court under Section 6 of the current Arbitration Act as it exists is the NCIA. It does not, in fact, give parties an opportunity, if the court decides that the matter should go to arbitration, to first decide or to first agree to appoint an arbitrator, failure of which the appointment can be made by the NCIA. The position seems to be that unless the arbitration agreement itself has assigned another body to appoint an arbitrator, if no such assignment has been or nomination has been made in the arbitration agreement itself, then it is an automatic process where the High Court or the court that is the seat of the matter will then automatically refer to the NCIA. I think there is an issue there about party autonomy as a principle. I believe that we can perhaps tweak with that particular provision and make or afford an opportunity for parties perhaps to agree, failing which then NCIA can come in. Engineer seemed to disagree with me on the issue of the involvement of the High Court, and his reflections were that to him, the High Court should not feature completely. I think if you look at Section 10, the involvement or intervention of the court has been limited to the extent only that is permitted under the Act. Of course, initially before this, as it stands now, the court plays a facilitating and enforcement role in terms of arbitration. Of course, the facilitating role, as we have seen, seems to be taken over now by the arbitral court, and the enforcement role is still reposed with the High Court. So it is necessary, engineer, that we still have the High Court, especially on the question of whether or not an arbitral award should be set aside. In my view, for public policy consideration, the High Court retains the jurisdiction, the supervisory jurisdiction of arbitral processes as well. Of course, within the purview, the limited purview that is envisaged under Section 35. And of course, when it also is faced with the question of whether or not to enforce under Section 36 of the Arbitration Act.
Thank you, Georgiadis. Emeritus, I'm seeing some questions still the arbitral court and the issue of NCIA arises there's a question by Evelyn from CIAB and then also Miriti. The issues on NCIA being a government or a statutory body, the questions of conflict of interest, independence, etc. are arising in those two questions. Maybe you could be able to address it. We know you don't represent NCIA, but maybe you could speak, advise.
Okay. Okay. This is what I'll say. We are trying to put together an ecosystem that interfaces seamlessly with the judiciary and then also with the private practice of ADR. And when I say that, I think because ADR is alternative to litigation, I think it's important for me, and I'll match the comment on the policy, that we had representation from the judiciary, and we had representation from 600, we had contributions from 600 stakeholders, and our committee had more than 20 people. So we thought that was a cross-cutting approach to thinking through how the structure would meet each and every stakeholder, and each one is using ADR in one way or another, some more than others, and then many of us were also providing ADR practitioner services. Now, we discussed at length the question of NCIA, and we know the challenge with NCIA being a statutory body and its connection and to the public sector. But NCIA is what we have as an institution that already has an international footprint. So we thought that it was important to leverage what we already have. And we must give credit to NCIA because they've done a superb job. And putting this into context, there are more than 100 institutions in Africa, ADR arbitration institutions to be precise. And NCIA is ranked at least within the top 5. So we said, let us leverage what we have. Let us leverage the system that we have, and let us consider. And when I say NCIA, the NCIA court appoints the arbitral court, but the arbitral court, they are independent. And even the Act already says that. So the question of, I guess, lack of independence is one more of perception than anything else. And ultimately, we will still have to sit and decide what to do. I'll give you the example. I believe it's KIAC, which had started, this is Kigali. It started as a statutory body, and to remove that perception, they actually ended up deregulating it and creating it as a private body. So even when we talk about the arbitral court in NCI, we are talking about an independent institution with representatives. We have now 15 because that's what the statutory provision provides for. But depending on the volume and the need, that is something maybe we can ask ourselves, do we want to leave it open and use or work on as need basis? So I've seen, Kibinji, your comment that yes, government is a very frequent party in arbitration. So that is something, and we can expect that there might be some kind of challenge to this. What I want to say is this: the bodies that are envisaged by the 3 statutes, the arbitral court, but the arbitral court is under NCI, the NCIA, the NDC is the National Dispute Council. They are independent. I kind of had that, like there was an perception that NDC power is gone. The NDC shares a registrar with NCIA. No, that is not correct. NCIA has its own registrar. The NDC has a secretary who shall be the registrar of the NDC. Please also understand, and this ties in with a comment about the specialized court. When we made the proposal we got from the judiciary is that they are more comfortable with what is being referred to as an ADR center, which is in the policy. And these ADR centers can then be referenced with by the PACs. Because the judiciary works with mediators, the judiciary works with arbitrators and conciliators, even though not as much as the other mechanisms. So their thinking was because they also have AJS, which is also a specialized practice, and it's emerging really strongly under the STAJ, then the judiciary ADR center would probably make more sense. We envisage it as having an ADR, a judiciary ADR center in every constituency, and all matters on ADR can then be handled at that constituency, or if it is the High Court with the bar bench, or even with the subordinate courts with the bar benches and the CUCs, because they all have their own system as well. So the key thing that we put in the policy was that the judiciary to work with the National Dispute Council, as well as all stakeholders, and the stakeholders would then mostly come from the practice area committees. Hopefully, with all these checks and balances, we will have a system that is speaking to each other, that is independent of each other, and ultimately gives a standardized approach to dispute resolution. The question of the technical court, the equivalent of the UK Technical and Construction Court, we also discussed this, and we were thinking of including it in the construction adjudication bill, but ultimately it was felt that perhaps we might create a specialized court like this and then not be able to provide for it, and also find, because we had not done a needs assessment specifically to have a data-driven decision-making approach, we could have possibly been what you call it, trying to solve a problem that we had not yet properly articulated. It's that if you create a technical court or a technical or ADR court for that matter, all it would take, and I'm saying this because this is, I will report what was said. All it would take is just 1 or 2 individuals manning that that bench for 3 or 4 years to destabilize everything that has been built in this country for the last 40 years. So we were convinced that it's best we allow the judiciary do what they do best and establish the systems themselves without also creating that nuclear potential outcome that could disorganize all that we have done. For the stakeholders, and specifically the construction stakeholders, the built environment stakeholders, IEK, EPK, NCA, ISK, and this, I've seen Engineer Kioko has raised it, Engineer Aluoch has raised it, QS Kibinji has raised it. The thinking is we do not want to formalize ADR. We want to standardize. The best way to standardize dispute resolution, not only in the construction industry or the built environment industry, is to give those people who are experts on a day-to-day basis a framework within which they can organize themselves. And our thinking, the best way was to have a practice area committee. The practice areas committees in arbitration could have the built environment practitioners. They could also have their practice area committee, subcommittee in the mediation ecosystem, in the conciliation ecosystem, and any others that may come, so that they can be able to be able to, first of all, change quickly if things in the industry changes, and then also to collect data and do their research, and then have more control. Because ultimately we are saying party autonomy. So that was the thinking behind the pacts. That is the thinking behind what has been put in statute today. So, okay, I've seen Miriti's comment as well. It really talks about the perception that I had also mentioned. Appointments. Who qualifies? Let's leave this to the practice area committees. We will not be able to. The word here is to compel. We do not want to compel the practice area committees to take definitions of who is a proper person, how they want to license. The licensing we envisaged would be done once a year. We also know that, and this is informed mostly because mediation institutions are very many. There's a potential that they will grow in AJS, and we don't know much about conciliation because it really seems to be focused in employment matters. But to give that, yes, to give, I've seen Prof has said something about qualification. Maybe I'll give him a chance to jump in on this, because we have been hearing interesting engagements in specialized area. Yes, so Marco Rocco, standardization should not establish, yes, this is a key factor. Let everybody manage their profession, let everybody manage their ADR area mechanism, let them be able to be represented across the board. Just create a framework where there is accountability. Mostly the institutions, if we say that CIAB will be the licensing body for arbitrators, then we say how you train them, how you certify them, how you discipline them, and then these frameworks for the pacts will also allow us to apply disciplinary procedures, and also to adopt the code of conduct, and also key standards like disclosure. So there's, we really tried to create a balancing act. Arbitration has the closest engagement with the court system. The arbitral court is really to make the process move faster, the procedural aspects. When it comes to the final award and to either setting aside or enforcement, that remains within the framework of what we have adopted on the New York Convention. So all those principles about the composition of the tribunal, public interest, those I think will survive in the way we currently know it today. So, I mean, we can expect interesting experiences in the different practice area committees, interesting experiences with how the courts will interpret what is happening under the arbitration, mediation, conciliation, developments, and also AJS as we move forward. I hope I've addressed the comments and the questions that I have seen.
Yes, Emeritus, I've seen you've addressed them, and I see we are a few minutes to 4. So I don't know, even as moderator, there are some comments I would like to highlight, and then from there, then we can now have your closing remarks, especially on the issue of the ADR policy outlook. But the few comments or issues that may be taken up for consideration is the issue of the ouster of the jurisdiction of the court. The provision looks like it's amending the constitution backdoor, because that's where we get the provisions of the courts, the various courts. So it's good to consider that and look into that, because the Arbitration Act then did recognize that the High Court is part of the judicial system. ADR, though alternative to litigation, should ideally be complementary. And then there's also the other issue in terms of how prescriptive the amendments are, because a lot of it goes into party autonomy. Different organizations have their rules. CIAB has its own, NCIA, SEDA, and several others. So in placing it in this act, which should be an act of general application, anyone should be able to use it, then prescribing it then may create conflict between the different rules of the different organizations people select and this act. So that's something that needs to be looked into. On the issue of the courts, again, they're supposed to guarantee access to justice and as well as fair hearing. So that's also, and I remember the professor mentioned or supervisory jurisdiction, but there's a lot more that it does. And then the final issue of the NCIA particularly, and I think this is emerging across not just this sector, but several other sectors, in the fact that the government is an industry player, but also a regulator. That then may pose challenges even to CIAB as we speak. It may pose challenges in terms of competitive. CIAB should be able to set up its own international arbitration center, just like anybody else. That is free market. That allows for free market function, and that is fine. And then finally, on issues of discipline and whatnot, there are already procedures available. Negligence, internal systems, CIAB has its code of conduct, etc., etc. That should be allowed to occur instead of, again, creating prescription on codes of conduct, because then much as you'd like to standardize, but again, that can also interfere with innovation within practice around the area. And then if the whole essence of ADR was to allow growth in terms of alternatives to litigation, then it should be allowed to do that. And many of the clauses that I've looked through just quickly seem a bit too prescriptive. There are also alternatives that you can actually pick up instead of necessarily putting it into the law, because then you'll always have to be constrained by the law for one thing or the other. So those are the comments in issues that I'm raising even as moderator. But maybe we'll go with Georgiadis, then Aluoch, and then Waihenya. In terms of your comments, last comments and thoughts. I don't know if Professor would be available to say something, but yes, please proceed. Georgiadis.
Thank you very much, Toto, for the good moderation and for my co-panelists. I think we should have more of this perhaps before the proposed amendments come to fruition. Clearly, from what we have seen today, there is need to relook. I think the questions and comments that are being made in the comment section also need to be taken up. I particularly have no problem whatsoever with the arbitral court, but in terms of its structure, and as you understand, sometimes perception is important. We need to find a way to balance the need to exclude courts, yes, the normal court system, but also we don't then create another bureaucracy which perhaps creates the impression that the government would want to have a stranglehold on the proposed system. I think for me, there's one issue that didn't come out quite clearly, and I had hoped it would be raised. If it can be taken up, the factors that the Court of Appeal would consider when it is entertaining an application for leave to appeal against the decision of the High Court, where it has either set aside an award or it has upheld an award. We need to take into consideration that last ground under proposed section 39C, that it can consider or it can allow an application on special grounds or special reasons. So, so that we are clear on that. And this, of course, in view of the fact that the jurisdiction of the Supreme Court, in my view, has been excluded with that provision that the decision of the Court of Appeal shall be final. And that would also speak to the constitutional mandate of the Supreme Court, because we know you can appeal directly to the Supreme Court, where the Court of Appeal has dealt with an issue regarding the application or interpretation of the Court of Appeal, but also there is a mechanism to allow for certification where a matter of general public importance has been raised. So we need to rethink around that and perhaps see how it can be accommodated. Otherwise, I think it is progressive. The last comment, and I had thought that perhaps I would raise this before Madam Emerita speaks. I know there were attempts to have a completely overhauled Arbitration Act. In fact, there was a bill in place. Why do we choose to do piecemeal? Why not just go with a full bill? Thank you.
Thank you, Engineer.
Thank you so much, and especially to my able panelists. Just been sharing paper with the emeritus chair and the privilege. My general comment looking at bill is a progressive one. It's a progressive act. I think it lines a lot of, cures a lot of challenges that we've been experiencing in the industry. Save and to few discussions that probably I wish that they would be considered, or probably when finally submit the comments on the issue of the courts. Yes, supervisory role. I think that one cannot be debated upon, but the greatest fear in even the general practitioners is to have the matter being escalated beyond probably the Court of Appeal and all that. But again, looking at the jurisprudence that we've had and the precedent that has been there, we can count how many matters have gone beyond the High Court or Court of Appeal to Supreme Court. One, two, I think there are two or three. The new case, and I think there's another one, probably, which is a good thing for a progressive nation and for a country that is, of our stature is good. Another thing that I wish probably to say is that in terms of the progressiveness of this policy, is the construction and education bill. None in Africa. The rest of the countries that practice construction and education is contractual and with no legislation. So I look forward to have this piece. We try our best to make it the best, probably to set the standard for Africa. And looking forward, probably it may be a case of reference. I look at the Construction Industry Payment and Education Act of Malaysia, 2014. Very progressive. Look at it vis-a-vis the Housing Construction and Regulation Act of the UK, 1996. And for that matter, the UK Act, they are trying to revise their Act 30 years down the line. I'll not be so much amused to have this Act today, and then in the next 2 years, they are grumbling again with it to amend. It will be one of the worst of our undoing in this season. Otherwise, thank you, my fellow panelists, the moderator, and CIF at large for organizing this. I rest my case. Thank you and have a good evening. Nice weekend ahead. Thank you.
Thank you, Engineer Emeritus. Any final thoughts?
Thank you. Thank you for those comments, and I'll join in on the comments, Madam Moderator, for your good moderation. I've just realized you've been calling me Emeritus. No, for ladies, it's Emerita. I think I want to be the first Emerita and not the former chair. My namesake, Lady Justice Jacqueline Kamau, said she was Emeritus. Yeah.
Well noted.
I had to be distinct, otherwise we'll have the exact same names in everything. Okay. First, I've seen our Vice Chairman, David Joroge, is here, and he was also a member of the National Steering Committee. So allow me to recognize his presence as our current Vice Chair and also as a member of the Steering Committee. I don't know whether he wanted to add on. This is what I'll say at the end of the really robust discussion that we've had this afternoon. And thank you everybody for your comments. They will really go a long way in enriching what will ultimately be our legal framework in Kenya. This is what we want to achieve. This is the first thing, to enhance the quality of our ADR services. What do we mean by this? To get the right people doing the right job, and also to make sure that we weed out those who are not doing exactly what we need to be accomplished. So there are codes of conduct. Please examine them to give teeth to the practice area committees, to us also to create frameworks for us to discipline our members. It is a real problem. It's not as widespread as many people seem to suggest, but it is there, it is real, and we do not want to give it space to grow like a cancer. Other than that, it's important for us to just create standard operating procedures so that we can bring predictability. People who are using our services can know what to expect. And that is also going to come in with what are we going to be paid? We are saying, let's have efficiency and make something cost effective. It's important that people know what the value of our services are and what they can expect to pay for them and what the turnaround is. How do we train? How do we grow? How do we establish ourselves in this profession? How do we certify people? How do we accredit them? How do we do our CPDs, and how do we engage with a regulator? We actually do not have a regulator at the moment. And then once we have all those, we can be able to engage with public awareness in a good and comfortable and a predictable way, with a foundation which we can always refer and tell people, look at this, this law says this, and this is what we are doing. So I'm looking forward to continued engagement with this process. It's exciting. It enables us to create knowledge development and management to engage with other jurisdictions. They're looking up to us. Many people have really commended what we've been able to do so far. And we have been an inspiration to countries not only in East Africa, but also around the continent, in the region, and ultimately even the world. And we've been able to put Africa on the map. So this is a really worthwhile area to grow and to build a community that everyone can be proud of. So there's so much say. I'm not sure we can be able to cover everything 100%. And this just gives me an opportunity to just segue into what Georgiadis asked about. Why are we doing this piecemeal? The reason we did this piecemeal is because our act currently is aligned to the in situ model law. We still want to maintain our designation as an in situ country, but also tailor it within the context of what happens in Kenya. There are a few things that are different here. With the High Court supervisory jurisdiction is unique to Kenya. And we also have a few other areas where we are growing faster than anybody else. Our adoption of virtual and electronic media in the way we communicate in Kenya, and how we also engage with the court system. So there are many things to learn and also to be engaged in as experts in this area. So I can assure you that you are in the right area, and we will continue to engage. I'm not going to really comment on what Engineer Alwood said about the potential of the construction adjudication bill. The potential is immense. He mentioned about the House's Grants Act, which created construction adjudication in the UK. Today, you cannot discuss construction law without knowing the construction law of the UK. So we need to get on that bandwagon. And because we are creating an Africa-based dispute resolution framework as a response to AFTA, and the commercial explosion, well, I call it an explosion because the economics, if it works out, will be incredibly good. I think this is the time to see that this framework, what we have put in place, not only speaks to today, but speaks to the tomorrow that we might not really know because there's so much uncertainty in the world today. But I do believe that we have the blueprint. I'll use your words from built environment. We have the blueprints to be able to take good advantage of what is coming soon. I think the last comment is, let's strengthen the institutional framework. I do believe that there is a role to play for each and every one of us. So thank you, Madam. Thank you, Mr. Thank you, my fellow panelists and the leadership in CIR. Thank you for the comments and for making sure that we'll be able to continue to engage with this subject. Asante sana. God bless you all.
Thank you, Emerita. Well noted. Thank you for your comments. I know we've overshot by about 10 minutes. Would you allow me to maybe give a minute or so to our Vice Chair, Njoroge, if he can want to say a word or two, say hello, maybe. And then now I will close out the session, then we'll have Secretariat give us the next steps. Vice?
Good afternoon, Itoto and members. Thank you very much for joining this session today. It is an important engagement that we seek to have with our members. And through your participation, your public views and your public participation, we'll be able to seemingly compile our feedback for this important exercise. So mine is to thank you, to thank the facilitators, Chair Emerita, Jackie Waihenya, well done. Thank you for the great work that you continue to do. It was indeed a pleasure also to serve with you in the committee, and also the chair for bringing this together and having us come together for public participation. We want to ensure our members that in such activities that we will be at the forefront to ensure that the voice of the members and the views of the members are well taken care of, because it is indeed our duty as the biggest stakeholders in this aspect to collect the views and ensure that they are compiled and taken in as we move in to the implementation of the policy and the forthcoming bills that will come. I want also to thank Jodiadis for the good work that he has done. Everything has positives and negatives, and opening our eyes to the aspect of the other world of the meaning of the proposed bills. It's a good thing, and I believe that we are well informed, and I want to leave it at that. Thank you very much also to the Secretariat and also Itoto for the very good moderation. Thank you very much. Back to you, Itoto.
Thank you, Vice Chair. Thank you for your kind words. I'd like to extend gratitude to the participants who have joined, who questioned, who also raised questions. We hope the session was informational, that you were sensitized, that it was thought-provoking, and we also hope that you could continue engaging the comments wherever you're able to, and also just provide your comments on the amendment bill. It's available. I'd like to thank the panelists who were able to address a lot of the issues and give us their thoughts and were provided good information. Thank you. Thank you to the Secretariat for organizing and whipping us into this. And we hope to have, as mentioned, a series so that we'll tackle the adjudication bill, construction bill that is close to the engineer's heart, and the dispute resolution bill in the coming weeks.